Is the forced reset trigger saga finally over? The Department of Justice has announced a new settlement in the FRT saga. Let's talk about it today. Hello, my name is attorney Rachel Moss, and here we are yet again for another update in the long saga with the forced reset triggers in the ATF. So we've spent a lot of time on this channel diving into this issue, giving you update videos over the years. And as a reminder, this has been going on for a long time. If you remember, rare breed triggers brought their forced reset triggers to market way back in 2020. And then soon after, ATF in 2022 published an open letter to FFLs, basically saying that they determined forced reset triggers are machine guns. And this launched all sorts of drama with litigation in New York, litigation in Texas. There were preliminary injunctions, there were permanent injunctions, there were appeals. Overall, a lot of back and forth on this issue with different circuits having different opinions and a lot of uncertainty for many gun owners who have purchased FRTs. Well, finally, it seems the drama might be coming to an end, as the Department of Justice recently announced that they have settled this issue with Rare Breed and the National Association for Gun Rights. If you really want a very in-depth background on this whole saga, we've posted a few videos in the past that we will link in the description below. But just as a quick refresher, if you don't know what a forced reset trigger is, it's an assembly that allows the trigger of a semi-automatic rifle to reset quicker than it otherwise would with a standard trigger spring. FRTs really came into the public eye after ATF published that open letter we talked about. In that open letter, they determined that FRTs are machine guns under the National Firearm Act. And as a refresher again, I'll read out what they claimed. It allows a firearm to automatically expel more than one shot with a single continuous pull of the trigger. So the NFA, the National Firearm Act, essentially bans machine guns to the common person. The last time I did an FRT video, I caught a lot of flack for saying the NFA bans machine guns. That's not entirely true. Yes, there are ways people can own machine guns. Military can have machine guns, officers can have machine guns. There's also some exceptions for machine guns depending on the age of the gun. However, effectively, the NFA makes it very difficult for the common person to get a hold of a machine gun. So I call it a ban because it effectively is one, but you're right, in the statute itself, it's not a total ban. But this is why the FRT issue was so important to many Americans. They purchased what they thought was a lawful item for their firearm, an FRT, and they later learned it is determined to be an illegal machine gun. One of the parties to this settlement, the National Association for Gun Rights, also known as NAGR, later filed suit in Texas in a case called NAGR versus Garland. This case was ongoing for a while, had a preliminary injunction at one point, and most recently, as we discussed in our latest video, had a permanent injunction. And this was considered a pretty major win for the FRT community. However, we knew that the United States government planned to appeal this permanent injunction. And we knew this was ongoing. There was also the lawsuit in New York that was going a different direction. So we knew at some point there was a good chance that this would either make its way up to the Supreme Court or there would be some other sort of settlement. And that's where we are now. On May 16th, 2025, the Department of Justice posted their press release announcing this settlement. And similarly, the NAGR also posted a press release celebrating what they called their victory against the ATF after years of fighting for the people to be allowed to own forced reset triggers. So the tone of the DOJ's settlement press release versus the NAGR's is very different. The DOJ really focuses on all the things that they're going to be requiring the NAGR and Rare Breed to do, where NAGR's is really a celebration of taking down the tyrannical ATF on this issue. So to read just directly from the press release, Pam Bondi stated, "The Department of Justice believes the Second Amendment is not a second-class right." Well, that's good to hear. But she continues to say, "And we are glad to end a needless cycle of litigation with a settlement that will enhance public safety." That's really important that she mentions the public safety element. A big portion of this settlement was really focused on promoting public safety in relations to FRTs. When you read the NAGR's press release, they focus on the fact that this settlement is allowing the common people to own FRTs again, and the settlement also requires ATF to return FRTs. But there's also some things snuck into this settlement that put a little bit of a burden on Rare Breed, who manufactures FRTs, as well as the NAGR. The DOJ cites Cargill versus Garland as a major factor in helping them reach this decision. We also did a couple videos on this case, but that was the case that really talked about ATF exceeding their authority in many areas, including bump stocks, and then here, what's relevant is in the area of the FRTs. Overall, the DOJ celebrates the fact that this settlement is allowing people to avoid continuous litigation on this issue, as well as promoting public safety. Now turning to the NAGR's press release, they state, "This decision marks a new era of holding the DOJ and ATF accountable when they trample the rights of law-abiding gun owners. We made them give back what they took, and that's a precedent they'll never forget." It's really great to hear the NAGR celebrating this settlement. But let's dive into what this settlement actually says. So here in the press releases, we hear what the DOJ thinks of it, we hear what the NAGR thinks of it, but there's a little bit more to the settlement that isn't really in the forefront of either press release. Diving into the settlement itself, I have it right here in front of me, the settlement agreement they reached. First of all, they go over the fact that this affects certain parties. So as a reminder, this lawsuit involves the U.S. government, it involves the National Association for Gun Rights, it involves Texas gun rights, as well as a few other specific named plaintiffs. So this settlement agreement is specifically for those individuals. The settlement agreement starts off by acknowledging the Second Amendment. So that's a good start. I love that they're stemming from the point of view that the Second Amendment is an important constitutional right in this country, and that everything in this settlement agreement should stem from keeping that in mind. So far, the settlement is off to a great start, in my opinion. Afterwards, they acknowledge the fact that the Gun Control Act and National Firearm Act here is very relevant. They cite to the definitions of machine guns and acknowledge the fact that they have to keep in mind what the previous definition of a machine gun is. Next, the settlement agreement acknowledges the history of all of this litigation. Basically, how do we get to where we are now, as we were just talking about? So they acknowledge ATF's open letter, they acknowledge all of the litigation that was going on, and they also acknowledge Trump's recent executive order. So Trump issued an executive order on February 7th, 2025. The executive order is titled Protecting Second Amendment Rights. So this order directed the Attorney General to review all actions of executive departments and agencies to assess their impact on the right to bear arms. And that's how we got here, because the government basically determined the litigation in this case is not supporting the public interest. So here they're keeping the rights of Americans in mind. What do the Americans want? What does the public want? And it does not support the public interest to go down some years-long litigation regarding FRTs. No, the Department of Justice wants this resolved for the American people. Now we get into the actual terms of the agreement. So really the meat of this settlement agreement. So the first thing that's very relevant is that within a few days of this agreement going into effect, the parties are dropping all pending litigation relating to this issue. So the main cases that we've talked about in the past are the Texas case, NAGR versus Garland, as well as the case out of the Eastern District of New York. That would be United States versus Rare Breed. There's also a similar Utah case that is being dropped as a result of this agreement. So that's good. We love that. No more litigation in this area. We're not going to have to go through years of appeals and discovery, injunctions anymore. This is taking care of the issue. So it's great for everyone wanting a final resolution on this issue. This agreement gets us there. It stops the litigation. It helps people get the answers they need on this issue. Another little agreement that I just think is interesting as a nerd, as an attorney, is that each party is agreeing to pay their own attorney's fees and bearing the cost of this litigation. It's interesting because often in lawsuits, a party that is considered the victor or the party that, was considered wronged in a way by the other party's actions, they will have their attorney's fees covered by that other party. So here, the fact that they are both covering their own costs, paying their own attorney's fees, shows we're not really declaring someone the winner here necessarily. This is true that we're just trying to reach an agreement here. We're settling this. We're not saying you won, you lost. Now the thing that's been getting the NAGR and the general public very excited. The next agreement is that ATF has to return all seized or voluntarily surrendered FRTs. If you remember, at the time that this was ongoing, ATF was sending out these crazy little notices to people, scaring people, saying, if you're in possession of an FRT, you've committed a federal crime here, and saying, we'll give you the opportunity to surrender this, and we'll be so gracious as to maybe not prosecute you. So ATF was definitely overreaching in these surrenders. They called them voluntary surrenders, but they were really scaring people and giving up what is now, as we know, should be legal property, did not violate the NFA, is not considered a machine gun. So the settlement agreement still calls it a voluntary surrender, but we know what it is. So this is great news. This is what we've been wanting the whole time. ATF righting their wrongs. They have to return FRTs to the American people. However, it is really important, if you were affected by this, if you had an FRT that was either seized or if you did choose to go through the surrender process to protect yourself from potential prosecution, there are certain steps you have to take to get your FRT back. So the deadline to request your FRT is September 30th, 2025. So you have a few months to do it. But if you're interested in getting your FRT back, you should get on it now. There are steps listed on the ATF's website. So again, if you're interested in getting your FRT back, head to the ATF's website and see what you can do. So again, this is something to celebrate. I understand why the NAGR is very, very excited about this victory. This is why they filed it. They wanted people to have their rightfully purchased property that is not in violation of the NFA. One caveat to this provision, though, is the settlement agreement specifically states that this provision does not apply to FRTs that are involved in pending criminal prosecutions. So if an FRT was seized as part of a criminal prosecution, you cannot get that FRT back. Now we get into some of the interesting stuff that wasn't announced in the press release. So something that I think some people will be surprised about is that per this agreement, basically the NAGR is agreeing not to pursue any claims against the United States. So a term of this agreement is that all of the named claimants to this lawsuit are essentially releasing the United States and its agents, including the ATF, from any litigation relating to the seizure of these FRTs. That means if any of these claimants wanted to later sue ATF for the illegal seizure and try to get some monetary penalty back for ATF's illegal actions, they can't do it. They are releasing ATF in the United States from liability here. This is a big deal because a lot of people thought, hey, we can potentially pursue monetary damages after this. The ATF was acting illegally. They were overreaching here. Maybe we deserve some sort of financial compensation for this. No. They are not able to pursue this sort of litigation. So while there is a major victory here in making ATF correct their wrongs, this settlement is also greatly limiting the people from pursuing claims against the ATF. Another specific agreement in the suit is all the named claimants are specifically waiving any claims against the ATF for seizing the FRTs without probable cause. So they get pretty specific here, that even if you want to go after the ATF specifically, the agents specifically, for the very specific issue of seizing the FRTs without probable cause, they cannot do that anymore. So again, it's greatly limiting the actions people are taking in holding ATF responsible. Now we get into even more limitations on these plaintiffs. Specifically, the next few terms limit Rare Breed triggers. As we've talked about, Rare Breed is the company that has been manufacturing FRTs since 2020. What this settlement holds Rare Breed to is that they cannot develop FRTs specifically for the use of handguns. That's right. This settlement greatly limits the type of FRTs that Rare Breed is able to make. So the further you get into this settlement agreement, it seems like a way for the government to retain control over FRTs. I think the government might have seen the writing on the wall here. The permanent injunction was granted against the government here. It looked like the case was going very well for the National Association for Gun Rights and Rare Breed, And I think the government knew they had a low chance of winning that case overall. Once there's a strong permanent injunction, like there was in NAGR versus Garland, it's a difficult case to win after that point. I think it's possible the government saw the writing on the wall and thought, okay, a settlement could complete all of this litigation, but also help us retain control that we might otherwise lose if we continue with litigation. And that's exactly what we see here. Rare breed is being limited by this settlement agreement. So the United States government has some control here now over the manufacture of force reset triggers. Rare breed cannot develop and manufacture force reset triggers specifically for handguns. The next provision, similarly seeing that government control. Rare breed is agreeing not to encourage or market possessing an FRT for the purpose of using it with a handgun. So again, it's not just controlling their development, their manufacture, but in a way controlling their speech, saying you're not even allowed to encourage the use of the product in this manner. Again, we're seeing the ways that the government can maintain control over this industry, even in the context of a settlement. Yes, the government had to take some hits here, but when they knew they were likely going to lose, this is a way for them to maintain control. The next thing Rare Breed is required to do is enforce their patent. So as part of this agreement, Rare Breed is agreeing to the fact that if there are competitors that pop up and violate their patent, they have to take strong patent enforcement action against these other parties, and they have to bear the cost of this patent enforcement themselves. Now you might ask, why does the government care about this? Why does the government want Rare Breed to enforce their patent? Again, it's a control issue here. They will be limiting Rare Breed as the manufacturer here. And Rare Breed has to bear the cost of it. So there is some benefit to Rare Breed there, of course. You know, if someone's violating the patent, that might cause Rare Breed to suffer a financial loss. But sometimes people might pass on patent enforcement. It can be an expensive process to enforce a patent, but here they've bound themselves to do just that. Essentially, Rare Breed is going to be acting as an arm here for the government to help the government see where are these FRTs being manufactured. Rare Breed is going to be making sure that these competitors are not popping up, again, making it easier for the government to track FRT production. Again, we have another small benefit worked in here for Rare Breed. So the next provision is saying that finally the government will process Rare Breed's federal firearm license here and allow them to get back into being an FFL. So that's positive for Rare Breed. Again, there are some things to celebrate in this settlement. The next provision, again, a great victory for this community. Reading directly from the settlement, it states the United States agrees not to enforce 18 U.S.C. Section 922(o) and the requirements of the National Firearms Act, Gun Control Act of 1968, as amended by the Hughes Amendment to the 1986 Firearm Owners Protection Act, or any similar statute or agency interpretation of 26 U.S.C. Section 584B, under which an FRT is contended to be a machine gun, under the following two conditions. So there are a couple conditions here. Basically what they're saying, they agree not to enforce it as long as the FRTs are consistent with what an FRT was determined to be in NAGR versus Garland. So again, that is a good victory here. It is good for the government not to enforce the National Firearm Acts against FRTs as machine guns in this way. And the second condition is that FRTs cannot be used or manufactured for handguns, as we already talked about. But again, overall, this is a major victory, something that should be celebrated here. There are some additional releases from both the United States and the plaintiffs releasing each other from all claims relating to this litigation. That's standard in many settlement agreements that you'll see. Okay, don't sue me for anything else related to this. This is saying that this is it. This is the final decision unless we both later agree to modify it in writing. And then there's a couple other vague provisions at the end that I think will be kind of interesting to see how they actually play out over the upcoming years. The first one, and again, I'll read this directly from the settlement agreement. It says the United States agrees to consider filing statements in support of RBT's civil actions for injunctions against patent violators, detailing the public interest to be served by the injunctions. I love that. The United States agrees to consider. So really, they're not binding themselves to anything here. It sounds good for Rare Breed that, okay, maybe we'll get some government support as we're going through our patent enforcement actions that we're now required to do. But really, the United States isn't bound by anything. They're just agreeing to consider. I could agree to consider almost anything. And guess what? If I consider it and don't do it, I'm not in violation of this agreement. Imagine this whole agreement if it had that language in front of it. The United States agrees to consider to return your FRTs. Okay, well, what if they consider it and say, no, we're not going to do it? That's fine under the settlement agreement. It's just language that's kind of pointless. It's interesting that it even made it in here. Maybe the fact that it's in here will put a little bit more pressure on the United States to actually buck up and do it, but they're under absolutely no obligation to do so per the language of this settlement agreement. The next kind of weird provision is that Rare Breed agrees to promote the safe use of their products on their website and post certain things on their website in support of safety. Again, there's not any specifics here in what Rare Breed has to post, how much they have to post, where they have to post it, what promoting the public safety actually means. So it's a very vague provision. It makes me wonder, could they get away with it just by putting a couple lines on their website somewhere? Rare Breed might want to, make a big web page about it and really go all in on public safety. But another interesting provision that we don't really know how it's going to play out until we actually see this settlement agreement in action. The rest of the settlement agreement are those vague lawyer language terms that you get in pretty much every settlement agreement. Boring stuff by saying, we have the authority to settle this agreement, things like that. So really what you need to know about this settlement agreement is that it is a major victory for FRT owners or people that previously owned an FRT that was seized or surrendered to the ATF. You now have a pathway to get your FRT back, and that is huge. This does put ATF in their place in a way because ATF is on notice that they have overreached and that there are consequences for those actions. But on the flip side of this settlement agreement, there are some things we don't love about it. I don't love that the government has found a way to get some control over this industry that they might not otherwise have had if the litigation had continued. However, anytime there is continued litigation and you go through the court system, there's a risk. Just because there's a permanent injunction at one point doesn't mean that the NAGR could have later lost this lawsuit. Let's say this lawsuit went on for years into a new administration that was less gun-friendly. There could be a real risk that they could lose that suit at the end of the day and ATF's actions could have stood. So here it is a victory. It's hard to know if they made the right decision by entering into the settlement agreement, but there are great things that have come of it, but also some government control over this area. I want to hear what you all think. Do you like this agreement? Are you glad that the NAGR entered it? Put your thoughts in the comments below. And remember, we are here for you. We want to make videos that you love. So if there's an interesting case, something related to guns or the Second Amendment that you want us to cover, let us know in the comments below. Thank you again for tuning into this video, and I'm glad we finally completed, hopefully, the long saga of ATF versus force reset triggers. However, if there's any updates about this in the future, we'll keep you up to speed. If you want to learn more about us, check us out at attorneysforfreedom.com. Attorneys for Freedom is the only law firm in the country that is exclusively committed to self-defense cases. So check out our website, learn about what we do, and meet our team there. You can also check us out on attorneysonretainer.us. Attorneys on Retainer is a self-defense protection program where if you join our program and you are in a self-defense incident and you can reasonably assert self-defense as a defense and you are charged with a crime or expect to be charged with a crime, your legal fees will be covered. So learn all about that program again at attorneysonretainer.us. Also, while you're here, you might as well go ahead and like, comment, share, and subscribe. We hope to see you next time. Peace.